What counts as self-defense in a domestic violence criminal case in California? That's exactly what I'm going to be explaining in this video, because self-defense as it pertains to a criminal case is actually not as simple as he hit me first. My name is Veronica. I'm a domestic violence defense attorney, and I help people throughout the entire state of California put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to represent yourself at a restraining order hearing and win. So if in addition to the criminal case you are dealing with a restraining order, make sure that you get your free first class via the link down below. Okay, so let's jump right in. What counts as self-defense in California? Here's the definition straight from the jury instructions in California. And don't worry, it is dense, but we are going to break it down. Number 1, the defendant reasonably believed that he or she was in imminent danger of suffering bodily injury. Number 2, the defendant reasonably believed that the immediate use of force was necessary to defend against that danger. And number 3, the defendant used no more force than was reasonably necessary to defend against that danger. Okay, so let's break down that first prong. Basically, you have to be afraid that the other person is about to physically harm you, and that belief has to be reasonable. Now, what does it take to have a reasonable belief that someone is about to cause you bodily harm? One thing that's really important and unique about domestic violence cases when it comes to self-defense is that when you're looking at whether the defendant's fear that the alleged victim was about to physically attack them, you have to look at the history between the two parties. If the alleged victim in the case has attacked you many times before, and you have seen exactly what their face looks like, or how they raise their fist when they are about to physically attack you, then that's going to be something that's really important to show that your belief was reasonable. This is something that the police often overlook, and that prosecutors and even defense attorneys who don't specialize in domestic violence, this is something that they often don't pay enough attention to. Another thing that's important here is that, especially for domestic violence cases, the other person doesn't have actually had to hit you. If they've come at you and physically attacked you multiple times in the past, and you know when it's about to happen, right? And you don't want it to happen this time, so you fight back, you push them away, you try to stop them. You might do that before they make contact with you. You don't have to let them hit you first. And there's one more important detail to this prong: imminent. Okay, immediate. This cannot be a fear of future harm. This has to be something that is about to happen. So if you are in an argument with someone who has abused you in the past, and you know that at some point during the argument, they may attack you. They've done that many times before. Maybe they've done that every time before, but they're not coming towards you. You just know that it will probably happen during the argument at some point. Or maybe they are abusing you every single day, and finally you decide, you know what, enough is enough, and you physically attack them. But they haven't come at you. You don't feel like they are about to hit you or physically harm you in some way. That is not going to meet the imminent or immediate requirement here. They have to be basically about to do it. All right, let's go back to prong 2. Prong 2 is that the defendant reasonably believed that the immediate use of force was necessary to defend against the danger. Where this often comes up, and where people will think, I have a good case of self-defense, but actually they don't, is where the other party hits you and then you hit them back. Unless they were gearing up to hit you again, that is not necessarily self-defense. Basically, it cannot be an act of revenge. You hit me, so I'm going to hit you back. Okay, this brings us to the third prong. The defendant used no more force than was reasonably necessary to defend against the harm. What this means basically is that you are allowed to use as much force as you need to stop the other person. So if they slap you once and they seem like they're going to slap you again, you can't necessarily just clock them. And it's situation dependent, and this is something that prosecutors will try to attack, especially if one person is a lot smaller than the other person or a lot less strong. You are strong, the other person's attacking you, and you are just trying to stop them. Prosecutors will try to argue that you use too much force. Another option is maybe the other person is a lot stronger than you, and so maybe you weren't able to just push them back and hold them back and get them to stop. Maybe you had to shove them harder so that they would fall over so that you could run away. That's just one example. And this third factor I do see come up a lot with arrests, where the cops come out, one person has injuries, the other doesn't, and so they will make an arrest. And at that point, what your attorney needs to do is contact the prosecution and explain your side of the story and explain how actually your case does meet these 3 prongs of self-defense. If it's your first arrest, sometimes a skilled domestic violence defense attorney can get your case dropped before court. But if it goes to court, these are the things that your attorney needs to focus on when they're going through all of the evidence, when they're going through statements that each one of you made to see, is the description that everyone gave of what happened, does that fit with self-defense? Do the injuries fit with this? Does this make sense? And they need to keep hammering that, because self-defense is a complete defense to the charges. If the case goes to trial and the jury finds that you acted in self-defense, then that is a not guilty verdict. I hope you found this video helpful. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell. And if you have any questions, feel free to leave a comment.